Good afternoon, everybody, and welcome to day 3 of the Bar of Ireland conference, the title of which this year is Human Rights, both at home and Human Rights abroad. I would firstly, before we start, like to thank our sponsors, and they are Aon and also Irish Life. I would also like to thank all of our attendees, because through your generous contributions, we are now in a position to disperse amongst our 2 chosen charities over €5,500. And those 2 charities are the Capuchin Day Centre and also the Irish Rule of Law International. That is a human rights foundation, which is run by Angus Kelly, who is a human rights activist. So thank you everyone for your kind contributions. They will be given equally to those 2 charities. I would also like to thank Orla O'Donnell, who is going to take over as presenter later. And I would particularly like to thank our 3 speakers, a triumvirate of justices who are giving of their time to address us on the subject of rights. And our first speaker today will be Baroness Hale. And before we move on to my own opening comments, I would just like to say that I noted in a book this afternoon entitled First 100 Years of Women in Law, that Baroness Hale has become known as the Beyonce of the legal world. So I just wanted to say that and quote from this book, which is available in all good bookshops beside you. So welcome, Baroness Hale. In addition, we have Ms. Justice Rosalie Abella, who is joining us from Canada. She was a justice in the Supreme Court of Canada. And finally, I would also like to extend our thanks and warm welcome to our own Justice of the Supreme Court, Ms. Justice Mary Finlay Gagan. So thank you to all 3 of you. Thank you for giving up your time. People might ask, why are we addressing the subject of human rights here at the bar? And the purpose of today's address in respect of rights is in commemoration of the fact that next November will be the 100th commemoration of the call of the first woman to the bar, not just in Europe, but the bar in Ireland and the bar in the UK as it was at the time. In those 100 years, we have made great strides in respect of equality, in respect of advancements towards greater diversity. In 1921, the first 2 women called to the bar were Avril Deverell and Frances Kyle. In 1925, we saw the first female professor of law here in Ireland, and that was Professor Frances Moran. In 1963, we saw the first female judge, Eileen Kennedy. In 1980, we saw the first female judge of the High Court, Miss Justice Mella Carroll, who the year before was the first female chair of the Bar of Ireland, some 41 years ago. In 1990, we saw Mary Robinson, a member of the Inner Bar, a member of the Bar of Ireland, the first woman elected as President of Ireland. In 2011, we saw Ms. Justice Susan Denham appointed as the first Chief Justice, the first female Chief Justice. And her words, and I quote, "standing on the shoulders of the pioneering women of previous generations." And there have been pioneering women, and there have been advancements in laws to protect not just women and children, but other minorities. We've had the Equal Status Acts that aim to ensure that there is no discrimination on the grounds of gender, marital status, family status, age, disability, sexual orientation, race, religion, etc. I just want to quote an aim from a politician in respect of the Sex Discrimination Act. The aim was to remove all existing inequalities in the law as between men and women. That was a statement by David Lloyd George in 2019. So yes, we have made some progress, but I would submit that there is a lot more to be done. And we here at the bar, we have to ensure that we advance diversity, that we advance equality, that we ensure that the human rights of all, particularly minorities, and those who could be prone to being oppressed, to ensure that their rights are protected and vindicated. Otherwise, what is the purpose of us being lawyers and us being barristers? So it is with that backdrop of ensuring the protection of human rights, some of which we take for granted. They're protected in this country because of our constitution, but abroad they seem to be trodden on. Certain parts of the planet don't even recognize women as persons. Certain parts of the world don't recognize gay people as being human beings. That is something we have to guard against, and that is why we have this presentation over the last 3 days on the subject of human rights. I would now like to welcome our presenter, our moderator, who is Miss Orla O'Donnell, who is an Irish journalist well known to us all as the RTE Legal Affairs correspondent. Orla has been regularly upon our television screens and has on numerous occasions presented from here at the Four Courts in the Distillery building and has commented on various cases as they have unfolded. Orla is originally from Dalkey in Dublin and started her career as Galway and Dublin correspondent for T.G. Carr from July 1996 until June of 1999. She then joined Radio Telefígera in June of 1999 and has appeared on RTE's main news programmes, both television and radio since. Since September of 2018, Orla has been the face of legal affairs on RTE. So I would like to thank you, Orla, and I'm going to hand over to you now.
Thank you, Maura. And actually, tragically, I'm doing legal affairs for a little bit longer than 2018, which is, and I'm feeling very old now. But when I was asked to prepare for this talk, I read a biography of Averil Deverell online. She's one of the first 2 women who were called to the Irish bar. And at the end of this article online, it talked about her brilliance as a golfer and how despite, or maybe because of her prowess as a golfer, one Joseph Healy in 1927 put down a motion to restrict membership of the Bar Golf Society to men only, and this motion was carried. And the biography online went on to sum up her career by saying, but that didn't matter to her, to a woman well used to the company of men and competitiveness and possessing a confidence born out of her performances as an amateur actress, the antediluvian attitudes of some male colleagues were hardly a barrier. And it said she went on to have a successful career as a barrister and retired in 1969, commanding respect and affection in equal measure from her colleagues. And I just couldn't help thinking that the writer there had glossed over 42 years of antediluvian attitudes from some male colleagues and no doubt from other males along the way. It couldn't have been easy for her to forge a career at the bar and to sustain her career at the bar before retiring as mother of the bar. 3 of our speakers tonight have also retired or are just about to retire, and they have forged stunningly successful careers in 3 jurisdictions. And of course, you yourself, Maura, are still at the coalface. And I'm hoping we get a chance this evening to see behind the gloss, that we don't gloss over things. Well, they were well able to deal with the men, so that's the end of that. So I'm hoping we get a little bit of an insight into the challenges they faced in their careers and the insights they may have for others. Now, I'm told they're going to refer to each other as Brenda, Mary and Rosie, but I am not that brave. And also you've asked me to introduce them properly, so I'm going to try to do that. And as I've said, I'm only giving a flavour of the kind of achievements that each of these women has. First of all, we have Lady Brenda Hale, the former president of the UK Supreme Court. She retired in January 2020. She was a teacher, a researcher, a writer at the University of Manchester and practiced, I think, at the Manchester Bar. Was also a member of the Law Commission before becoming a High Court judge in 1994. In 1999, she was appointed to the Court of Appeal of England and Wales, and she became president of the Supreme Court in 2017. And of course, she famously announced the decision of that court in relation to the proroguing of Parliament in 2019, becoming a bit of an internet sensation in the process. From Ireland, we have Ms. Justice Mary Finlay-Gagan, well known to members of the Bar of Ireland. She, according to her details, studied maths and physics in UCD before turning to law. She was admitted as a solicitor in 1973, became a partner in McCann Fitzgerald in 1979. She was called to the bar in 1980. Became a senior counsel in 1988 and a High Court judge in 2002. And in 2004, she became one of the judges responsible for the commercial list in that court. She was a Court of Appeal judge from 2014 to 2017 and then became a Supreme Court judge before she retired. Ms. Justice Rosalie Silberman Abella was the first Jewish woman and first refugee appointed to the Supreme Court of Canada in 2004. She was born in a displaced persons camp in Germany, and her family came to Canada as refugees. She was called to the Ontario Bar in 1972, and in 1976 she was appointed to the family court at the age of 29, and intriguingly, she was the first pregnant person appointed to the judiciary in Canada. And she has written over 90 articles and has co-edited 4 books. And you, of course, Maura, will be well known to everybody here today, but you are, I suppose, well known for being the second female chair of the Bar Council of Ireland, the first one being Mela Carroll 41 years ago, I think. Quite an achievement and quite a long time coming, as we all observed over the years. So speakers with a great insight into the law and into the challenges that are faced by women working in the law. I suppose maybe I'll start with Ms. Justice Abella. Your family came to Canada as refugees. You were born in a displaced persons camp in Germany. Did your background spur you on? What made you choose this path? Was there a particular determination in your life?
Oh, it was defining my background. My father had been a lawyer, a graduate of the Jagiellonian University in Krakow before the war. And as you know, the European legal system was 8 years of training. But he married my mother on September the 3rd, 1939, when the war broke out, and never had a chance to practice law. They spent the war in concentration camps, most of the war. Their son was killed, my father's whole family. And after the war, they went to Germany, where my father taught himself English in order to apply to work for the Allies in Southwest Germany. So the Americans hired him to set up a legal system for displaced persons in Southwest Germany. And we were there for 4 years until we finally got permission to come to Canada as refugees. In 1950, almost as soon as we came, he went down to the Law Society and said, I have practiced in Germany. I have, here are my qualifications from Europe. What test do I have to take in order to be a lawyer? And they said, you can't take any test, because to be a lawyer, you have to be a citizen, which he, of course, wasn't. Would have taken 5 years, and he had my mother, my sister, and my grandmother to support. So he became an insurance agent and never complained, happy to be in Canada, in the safety and security of the country. But the day he came home is one of my earliest memories in Canada, when he told us that he could not practice law. And that was the moment I decided I was going to be a lawyer. I had no idea what it meant. I mean, how can you know when you're 4 years old? All I knew was he was being deprived, I thought, of something unfairly, because he had these qualifications. He spent all of these years. He had suffered enough. The Americans had hired him, and he was not allowed to practice. So I said, fine, I'm going to be a lawyer. 4 years old. So it was a childhood dream until, and I stuck to it until I read Les Miserables. And reading that book was when I connected injustice to law and realized this is somebody who spent 19 years in jail for stealing a loaf of bread. So it was Hugo who kind of brought me into the possibility that law correcting injustice was something that I could do, which fit into my background as well as the child of Holocaust survivors. So I never stopped thinking that I wanted to be a lawyer. I knew no women who were lawyers at the time. People kept telling me girls aren't lawyers, but I didn't care, because my parents said, why not? And so I did it. There were 5 women in law school with me out of 150. And I found, to my great relief, that childhood dream to try to replace the dream he had of being a lawyer turned out to be such a fit for who I was and what I wanted to do. Being a lawyer for me is probably the most noble and majestic role you can play. Orla, I feel journalism is really fundamentally important. You have a justice role to play as well, but it has been a privilege to participate in this generation's pursuit of rights, human rights, the development of justice for women, minorities, persons with disabilities, Indigenous people. I think we've had Copernican revolutions, one after the other, in all of these areas. And I've had a front row seat on a lot of it. I've had a bit part on some of it. And I can't believe 2 weeks before my retirement, looking back now, as I finally am allowing myself to do, that this generation has done so much to fix the injustices. There is, as Maura says, a lot left to do. There will always, the business of human rights will always be booming. But what we've done so far gives me hope, at least in our countries, that will be a trajectory that continues towards increasing inclusion, increasing justice, and the diminishment of injustice.
And Lady Hale, would you agree with that, that was your childhood dream to become a lawyer? And would you have had similar aspirations, or what was your hope when you were younger about going to law?
Well, it wasn't a childhood dream. I didn't have anything like the exciting story that Rosie has just told us. But I was the first girl from my little girls' high school in North Yorkshire to study law. And I'm fond of saying that the reason why I chose to study law was that my headmistress did not think I was clever enough to study history. So we looked around for something else that I could do. And I had been inspired by the English history of the 17th century. That was the crucial century in English history when we basically had a rebellion, killed our king, restored the king, got rid of his successor on terms that we now had a constitutional monarchy. And a lot of brave things happened in that century. So that is, I think, why I said to my headmistress, when she said, well, I don't think you can do history, I said, well, how about law? And that's why I went off to do law. And of course, I found that there was a huge amount of interest in law. It is such fun, is it not? A lot of people don't think law is fun, but actually, Rosie and I both think law is a great deal of fun. There is so much to it, and there is so much harm that can be done through legal processes, but there's also so much good. And it's our mission to do as much good as we possibly can with it.
You were in academic life in the University of Manchester before you became a judge. That was a rather different path. What challenges, how did you make a transition then into being a judge in court?
Well, you'll have to ask other people about that. I went to teach law at Manchester University after leaving Cambridge, partly because they suggested that I qualified and practiced as a barrister as well as doing teaching. They thought it would enrich my teaching, and they were right. And in those days, you could qualify as a barrister by taking a self-tuition correspondence course, which is what I did. Cost me £20, I think, for some nutshells and model questions and model answers. Just shows how easy the bar exams were in those days. But that meant that I could then qualify as a barrister and do some practice, which I did for a few years, as well as teaching. And without that experience, of course, I could never have become a judge, because you have to be a barrister or a certain sort of solicitor in order to become a judge. But I had to choose between the teaching and the being a barrister, because you can't go on doing both successfully for any great length of time. And I chose to stay in academic life, all sorts of reasons, but mainly because easier to combine with having a family. And my husband at the time was also starting out at the bar, and we thought it would be a good idea if one of us had a steady salary. Academics are not paid a lot, but they are paid. Whereas, as the barristers will know, it can take quite a long time to get paid, and sometimes you're never paid. So it seemed like a good idea. And so it never occurred to me I'd become any sort of judge. But everything that I did as an academic led directly or indirectly to a public appointment. I wrote a book about mental health law, which led to my becoming a member of mental health review tribunals, my first judicial appointment. I started a journal of social welfare law, which led to my becoming a member of the Council on Tribunals, which I think also led to my being tapped on the shoulder to become a baby judge, part-time judge. We rely a lot in England and Wales on part-time fee-paid judges. We couldn't do without them. And they're the inevitable start to a judicial career. And then I wrote a book on family law, which I think was a reason for my appointment as a law commissioner. So after 9.5 years in public service, they plucked up courage and they thought, well, we could do with more women on the High Court bench. Who do we know who might be okay to do it? Oh, yes, we know Brenda. She's been in the Law Commission. She's been making a success of that. She's not been in court very much, but she has been judging for 9.5 years too. So let's give it a punt. So they took a risk and appointed me. That's the story.
Ms. Justice Finlay-Gagan, you didn't heed this warning either about getting involved with somebody who was also involved in the law, but you chose to continue on and to become a barrister and practice. What spurred you on in your career, especially practicing in the commercial area, which even in recent years, many women say is a very male-dominated area?
Well, I mean, my story, a bit like Brenda has said, is far less exciting than Rosie's story. But on the other hand, I think my initial challenge, as it were, when I was leaving school was I could always do a few sums. And I decided I'd try and do an honours maths degree. And I was told, no, women don't do that. I was advised that the last woman who had tried to do an honours maths degree in UCD had had a mental breakdown and I should avoid that. Anyhow, I did that, got through it, did okay. And then I decided really that mathematics, I regret to say in Brenda's presence that academia wasn't for me, nor some of the other options that were available, becoming an actuary or going into computers and things, which mathematicians seem to do a little, weren't. And I really wanted to work with people. And I had seen, my father was practicing barrister at the time, and I had seen how much Dad had enjoyed being a barrister. And initially in 1970, when I decided to study professional law, I said I would give the bar a go. And Dad, who had brought me up to do anything and think I could do anything and encourage me with the maths and everything, he said to me very firmly, strong advice, the Irish bar is not a place for women. And I regret that I never kind of teased completely out with him why, but I think he probably thought that I'd get frustrated because I mightn't get the work. And in fairness to him, it must be remembered that in 1970, the Irish bar, which comprised only 250 people practicing the law library, there were only 12 practicing women. They were 5%, and there was no woman silk at the Irish bar in 1970. So Mella Carroll didn't take silk till 76, and she was the first practicing barrister. Fanny Moran had been given silk as an academic, but wasn't. So I went off and became a solicitor, and I never regret it for a moment. And that, it's a long way of answering your question, Orla, because that led me into the commercial work. I was incredibly lucky, both in my apprenticeship as a solicitor with John Gleeson, and then I joined McCann Fitzgerald, and I joined with another friend who had done solicitors with me, a male, and the two of us worked directly to the senior partner, Alexis Fitzgerald, in McCann Fitzgerald, and we were both in the commercial department in McCann Fitzgerald starting in 73. And Alexis never made a single difference between myself and my colleague Dara Hogan. And he threw work at us that I think in retrospect, we were probably unfit to do, but you met the challenge, you got on with it, you did it. And I got incredible experience, and I was never treated any differently to any of my male colleagues. And we were made partners very early in McCann Fitz and everything. But I found myself at just about the age of 30, doing quite a lot of administration. It was very interesting being involved in the running of a big partnership, but also and the commercial work. But I had a hankering to give the bar a go. So I went in 1980. So I came to the bar with a commercial law background, a practice in commercial law around the city of Dublin. And, colleagues who I'd worked with from other firms knew that was my background, and I was lucky enough then to get into a practice in that area of law. But it was due to my experience as a solicitor that I really was able to get into that.
Do you think that that made you pretty unique in terms of commercial law and being a woman practicing in commercial law? Because it seems to be still an issue in the bar today that not as many women get briefed. And if you remember the gender diversity survey carried out in 2016, some women said that some men didn't want a female barrister, that they would feel that that looked weak when they were fighting a big commercial battle. Did you come across that?
Well, that was said, undoubtedly, and there were clients probably who had that sentiment. Certainly going back in the day, I think there are a lot of very bright young female barristers now who are doing a lot of commercial work. But certainly when I was practicing as a junior, I can think of one other very distinguished woman who ended up in the Supreme Court, Fidelma McInnes she came in from an IP background. And again, she had worked before she came to the bar in intellectual property, in a patents. And the two of us were doing a commercial practice. But I suppose it's correct to say we were. There were only a couple of us. And particularly when I took Silk, there probably wasn't. I took Silk a good number of years before Fidelma, and there was probably no other female doing a commercial practice. Mary Lafoy was doing a bit more on the conveyancing side. So it was, but it didn't do me any harm. If you're the only person doing something, people remember you. So that was, there were pluses and minuses, and I'm sure there was work I wasn't given. And I think, particularly as a junior counsel, a couple of years after us in the bar, I married and had 3 children in 3 years, and you just couldn't do the work, and you didn't get some of the fancy commercial work. But, you have to make choices, and I didn't regret it at the time. I wasn't able to be up all Friday night and work all day Saturday to prepare the injunctions for Monday. You weren't able to do it. But I did miss out on work, whether it was because I was a woman, whether it was because I was a mother with young children, I don't know.
That's certainly an issue that we'll come back to, I think. And I just wanted to ask Justice Abella about I was struck by your childhood idealism about the law, about being inspired by Les Miserables and The Loaf of Bread and Jean Valjean. Is that something then that you actually put into practice? Did you, when you actually became a barrister, became a lawyer, did you feel you were fighting injustice? Because, for example, a lot of us who go into journalism feel that we're going in to right wrongs, to make the world a better place, and we end up collating people's comments on Twitter. Did you actually feel that the reality lived up to that childhood idealism?
I never stopped to think about whether that childhood idealism was being challenged or not. I mean, when you practice law, as everyone who has done it will tell you, you practice client by client, case by case. I did everything that walked in the door. I did criminal law, real estate, corporate law, civil litigation, family law, virtually everything. And idealism was not anything that the human rights kind of speeches and lectures that I do now was not what I was about. I was about trying to fix for my clients the pain they were in. And you learn what it's really all about, that it's not about you when you've got somebody sitting across from you saying, fix this legal dilemma that I'm in. So for instance, it was considered a failure in those days if you went to court. I mean, the trick was to resolve the case without ever having to subject yourself to the possibility of a judicial fiat, which offended both sides. So I wasn't thinking, am I doing the idealistic thing? But what it got replaced by was an understanding that really what professionalism was a commitment to integrity, to compassion, to understanding what the world looked like to the people who were in front of you. The idealism was really for later. It never left me, but professionalism is a bit about idealism, but it's mostly about doing the job as well as you could for every single client who's in front of you, and in a way that every lawyer you dealt with would say she was fair. She was tough, but she was fair. So I don't know that. I mean, it's a very good question. To what extent does that still drive you? I would say more and more and more, because of what I see is happening to the rest of the world, am I tenaciously idealistic about what kind of world I want to see. But that's almost a separate piece from what kind of a lawyer and judge do I want to be. So the transcendent piece is judges should be committed to, lawyers and judges should be committed to the idealism that justice represents. But the day-to-day is, are you doing your job with professionalism? And can people look at you and say, she did it honestly, with decency, and she's earned our respect. Really, that's what it comes down to. So they're two separate conversations. I understand what you're saying, and that other part never leaves, that little part of my gut that drives me. But mostly what I felt was, Orla, there were so few of us, and I'm sure Brenda and Mary had the same thing. I knew that it was almost incumbent on me to work twice as hard as anybody else. That never left me. But also that if I didn't do a good job being whoever I was, and I was many things in my career, I was very lucky, they would say, you see what happens when you have a woman? So I was very well aware that we are each the early ones, pioneering metaphors. And I don't think I've ever met a lawyer in our generation early, and I never met another woman in the courtroom, by the way, who wasn't concerned about making sure that people didn't say it's an experiment that didn't work. So although we each took professional risks, we were not going to put our successors at risk by not doing the best possible job we could do in whatever area we were in. So this has been a fascinating conversation for me, because you have academic excellence, you have commercial law excellence, and it goes to something else that used to float around the profession in the early 70s. To be a really good judge, you had to follow a certain stream. And we now understand that being a really good judge, for instance, is having a portable tool called a good legal mind, and it can learn different areas. So you don't have to just be a civil litigator. You aren't precluded because you were a family lawyer. You aren't precluded because you just did commercial work. Everything produces good judges if you have what it takes to be a good, open-minded judge. But there's no question, as they've told you, there were certain streams that made the judiciary less inevitable than it was for certain other people. And I knew a lot of men who went into the career saying, one day I want to be a judge. No woman ever talked like that in our day. We were just lucky to be in the profession.
We're just having a little bit of internet difficulties. I'm surprised we got this far without any internet difficulties, but here we are. Everybody froze, but we're back again. What I was going to say there, yes, Frances Kyle, I think one of the first, the other first female member of the bar, she actually echoed what you were saying there, or said what you were saying there about when she was asked why she didn't go into conveyancing, where she wouldn't have had to go to court. She said she felt a responsibility as one of the first to practice and show the way, although I don't think it quite worked out like that for her in her life. But what's your view on what Ms. Justice Finlay Gagan was saying there about having to make choices? As I said, I was kind of struck by the fact that one of the intriguing things about you as being the first pregnant member of the judiciary. How did that come about, and how did that affect your work, or did it?
I think I heard what Mary said, and it was interesting. I never felt I had to make choices because I didn't think they were mine to make. And that may be because we were immigrants to Canada. So we lived in terms of what opportunities will be presented rather than what choice am I entitled to make. And I don't mean, Mary, that this is a sense of entitlement that you had, but I wanted to go to law school. After that, I put a seatbelt on and I just went on a trajectory through the career. And it was like that songwriter, Tin Pan Alley songwriter Sammy Kahn. Somebody once said to him, what came first, Mr. Kahn, the words or the music? And he said, the phone call. And that was my career. It was, do you want to run a labor board? Sure. Do you want to run a law reform commission? Okay. Do you want to be a judge, even though I was pregnant? everybody said, don't. The family court is the bottom of the judicial hierarchy. I said, I don't care. I don't even know any judges. And they want me to be a judge. Of course, I'll be a judge. So I never made these choices. I just accepted the opportunities that came along, knowing I would work very hard to do my best to do them well. So, I mean, it's a different framework. And I think if I had left law school saying one day I want to be a judge, I would not have taken any of the professional risks that I took in my career, because I never had an end goal. One day I want to be. So nothing I did was measured against the possibility that it would enhance or reduce that prospect, because I never presumed any prospect. So choices, no, but a lot of good luck, because, you know, having children is having a family, wanting to do well. We didn't talk about work-life balance in those days because we knew there was no such thing. You were working all the time. You were with the family all the time. Nobody ever said, gee, have I spent my 3 hours this week relaxing? Like you just, and no leaning in or out or up or down or any of that stuff. You just did it. And then as now, the three of us look back and say, I can't believe I did it. So we had no idea how it was going to work out.
Lady Hale, would you echo that? Did you feel you had to make choices?
Well, I would certainly echo no game plan, no idea how it would work out, seize whatever opportunities came along, even if they seemed quite scary or risky ones. Like when I was asked to become a judge, having not been in court then for 10 years. Now, that was a pretty scary thing to do. But I seized that opportunity because it seemed like an interesting challenge. Now, I'm not sure that Rosie is completely right, because she did make choices. She made the choice to seize the opportunities that came her way. And again, I made the choice to seize the opportunities that came my way, even though they were great surprise in many situations. It was a great surprise, but it has to be done. And then you do the best you possibly can at the new opportunity that's come your way. And maybe it leads on to something else, but not a game plan. I quite agree. I didn't have a game plan. I think probably by the time I was appointed to the High Court, I was hoping that I would be appointed to the High Court, because they were looking for women really quite deliberately then. And the trouble was there weren't a lot of us about. And so there have been points in my career when it was a positive advantage to be a woman. And I think that was true when I went to the Law Commission. I think it was true when I went to the High Court, even when I went to the Court of Appeal, and certainly when I went to the House of Lords. So in our generation, there were plenty of opportunities to be the first woman this and the first woman that. I feel sorry for the younger lawyers now. There aren't so many opportunities to be the first, but there are plenty of opportunities to be excellent professional lawyers, with a much greater opportunity to aspire to the top in a way that Rosie and I never felt that we could.
Maura, what's your view as someone who's still operating at the coalface? Do you feel that there is this, you know, do you feel you have to make choices, or do you feel there's this freedom to grab every opportunity that comes your way? And for the people you represent, do the women that you represent, do they feel like that, or do they feel pressured? Do they feel they have to make a choice between their family and the bar?
The bar is slowly opening up, but I think particularly young married women or young women with children find, for example, as we found with our Minister for Justice, that there is very little scope for the equivalent of maternity leave or childcare, which is a huge issue now. Most people work in this day and age. Most couples have to work if they're together, whether they be male and female or same-sex couple. They have to work to pay their mortgages, pay their bills. And if they have children, they have to pay for childcare. And we don't have childcare here at the Four Courts or in any of the court facilities. They're not allowed or prescribed by the court service. I'm not sure there is one in Dáil Éireann, which would be our Houses of Parliament. But that is definitely a hurdle. And the rearing of children invariably is left to women not to the male counterpart. Some do, but the majority of the rearing of the child seems to be left to females. I'm probably going to get shot now and castigated by my male colleagues for saying that. But that is the reality. And there are certain instances where, even in my own, I'm nearly 30 years now at the bar. I'm originally from Leitrim, so I practiced on the Northern Circuit, Midland Circuit, and then since I took Silk, I've been here in Dublin all the time. But you'd come across certain cases, excuse me, where the client would look at you and say, you're representing me, kind of looking behind you at some chap who's 6'2" or 6'3", and you could see it in their eyes, longingly wishing that would be their barrister. But invariably coming back out of court, they wanted to clap me on the back and bring me for a pint. But I was very lucky in that regard. But you could see it. It's just a difficulty, and it's an inherent issue in our society where it has been male dominated for so long. As I say, it is slowly changing, but it hasn't changed enough. And I feel sorry for those who are in minorities in this country, because despite the Discrimination Act outlawing discrimination against women, and despite our Equal Status Act, we still have discrimination against minorities. It's still seen very much as a male-dominated society, male-controlled society. The majority of our politicians are male. The majority of decision makers tend to be male. I'm not so certain they've made such a great job of it over the last 100 years, but that's an entirely different conference and debate. But thank you, Orla.
Orla, I wonder, can I just clarify what I meant by making choices? I just don't know if Justice Abella picked me up correctly. I continue to practice throughout, but I do think within that, and within, as Lady Hayla said, when you are given opportunities, you have to make choices. Are you going to take those opportunities? And as a practicing barrister, you are, rung up and offered work sometimes, and very interesting work. But if you have another commitment on that day already, you do have to make the choice. And I made the choice when I had children. I worked right up till the day, or actually, though obviously the clients and solicitors never knew, to several days past the due date of the children. But I did make a choice to take a couple of months out of court, even though we had no maternity leave or anything after the children were born. And I've no doubt that damaged my practice, because they said, oh, she's not available, because you had to say there was no such thing as an acknowledged maternity leave. But you can't bilocate. There are 24 hours in the day. And I think everybody has to work out, how do they solve pursuing their careers and also giving of their time to their family. And it's a personal decision, and people's circumstances are different. But I'm certainly a huge believer in taking opportunities, and it killed me on occasion when I couldn't take up something because of a clash. And the clash might have been some other work too sometimes, but I do think that we do have to make choices, and those of us with family commitments, that's one element of the things that we have to put into the equation when you're making choices as to whether you're going to take up opportunities or what you're going to do for the next 2 weeks or whatever.
You think that
sorry.
You go ahead.
I just think more. These are two very important points, because we have been, the three of us, we're now at the stage where we can say we've been very lucky, and we've been able to figure out for our own benefit how things work. But look at the changes in the legal profession. It's now about 50% of women in the legal profession, certainly in Canada. But look how many women are leaving the profession. So your point, Maura, about how we think because we have the numbers now, we have succeeded finally in an egalitarian approach to the legal profession, without acknowledging this reality that somebody, if you're going to have children, and we do, families are so important. If you decide that you want to have children, the profession has to accommodate that reality. And for me, I have never understood how, on the one hand, government policy can be, of course, women have the right to work, without recognizing that unless you give childcare, make that available so that they're not getting up at 5 a.m, going to another end of the city to put their kids somewhere, coming home and then doing full-time unpaid work after their underpaid work. And I'm not just talking about lawyers. We're dreaming in Technicolor. It's not going to happen without the childcare. So either be open and say, okay, we don't want women to work. We were kidding. We don't want women to work. But if you do, and as you say, Maura, sometimes it's a competition between poverty and working. They don't have a choice. They've got to do it. We have to finally figure out how we're going to accommodate that very important human reality of women, particularly, still having the primary responsibility, at least psychologically, and making it possible for all of those choices that men have and should have available to them. So taking childcare out of it, it's not going to happen. Are the firms adjusting? Are they saying, okay, somebody has God forbid, a heart attack, gone for 4 or 5 months. Everybody understands they have no choice. Maternity leave for 6 months? Are you really serious about your commitment to the profession? I mean, the whole perception still is rooted in, this is the way we've done it. Why can't you do it the way we've done it? Well, you can't. It just isn't true for most women and most men. So I think that's a huge hurdle. Numerically, we've been very successful in increasing at least women in the profession, but we have not succeeded in keeping them. And that makes me very sad.
Yeah, it's whether or not there's the support there to make those choices or to be able to make those choices. And I think a lot of women might say that they're not able to choose, they're not able to go to take a few months off after they've had a baby or whatever. And I suppose the figures here seem to show that while judges, we have an almost, well, we're getting there in terms of equality between male and female judges. When it comes to senior counsel, the senior lawyers, I think it's 17% of senior counsel are women, the latest figures that we have. I was wondering, Lady Hale, have you noticed this in the UK in terms of women being less represented at the higher levels of advocacy? Like, some of the cases that you've been involved in have been huge cases that have been concerning these very important issues. Have you felt that there are fewer women involved?
Well, definitely there have been fewer women involved. If you think of the two most notorious cases that the Supreme Court of the United Kingdom decided recently, the two cases brought by Mrs. Gina Miller, challenging various aspects of the government's activities in the run-up to Brexit. In the first of those cases, I think there were about 11 counsel who actually addressed the court, of whom only one was a woman. In the second of those cases, there were probably 7 counsel who addressed the court, and none of them were women. So that is a sad fact. Although we do have some star performers in the Supreme Court who are women, and everybody would acknowledge that. And just as in Ireland, the number of women Queen's Counsel has been going up at 1 percentage point a year, roughly, over the last 10 years. So we're about 17% as well. And that is, as I say, about 10% better than it was 10 years ago. But could I make one other point? We tend to think of success in the law in terms of becoming senior counsel or a prominent advocate or a partner in a big firm of solicitors. What a lot of women who want to balance their family and professional responsibilities in fact do is they may take a little bit of time off when they have children, but what they then do is move sideways. They go into other sorts of legal work. They go into the government legal service, for example. In England, and I suppose Wales too, 60% of government lawyers are women. They go into local government lawyering. They go into advising magistrates' courts. They go into the regulatory world, which is an enormous world these days. things like the Bank of England, things like the Financial Conduct Authority, things like the Financial Ombudsman Service, those sorts of things, which are sort of, some of them regulatory, some of them part of the dispute resolution mechanisms that we have. A lot of women go into that, and a lot of women become in-house counsel in commerce, finance, and industry. I think they probably have a majority in those fields as well. So what bothers me is that we tend to think of success, and we tend to think of judicial appointments in terms of the traditional bar and solicitors, whereas there are all these other brilliant women around there who ought to be regarded as candidates for judicial appointment. I think particularly of the government legal service, because their job is to tell truth to power. They have got to.
I've got some questions coming in here, so I'll try to put some of the questions that are coming in from those who are watching this discussion. And just on that, do you think that a female lawyer, the question is, would a female lawyer produce a different experience of dispute resolution? Is there a difference between how a woman lawyer might approach something, or is that an irrelevant question? I mean, is there any difference at all? For example, in those cases that you've talked about where many of the advocates were senior men, would it have made a difference if they were women? Would there have been a difference in the way they approached the case?
Most of the time, we are lawyers first. And we have, as Rosie was saying, the objective of doing the best we can. If you're a lawyer, an advocate, your objective is to do the best you can for your clients. A former colleague of mine, Sir Stephen Sedley, has said that the job of an advocate is to reason from a given conclusion. In other words, you work out what result your client can best expect, and then work backwards as to how you can persuade the court to do it. Now, I think that is quite a good summary of what a good advocate does, but it's the reverse of what a good judge should do, because a good judge should start with the evidence, with the legal materials, with the arguments, and work towards the conclusion to which they lead. You don't start with a conclusion when you begin to hear a case, or at least you shouldn't. I hope I'm not sounding too pompous or too virtuous, but a judge who goes into court knowing what the answer is not, to my mind, a good judge, especially in a difficult case. So, but I don't think that's a man-woman thing. To go back to your question, I think that is just an advocate versus judging thing.
Just Isabella, you wanted to come in there?
I just wanted to agree with something that Brenda said about the capacity for judging coming from on what we used to think of as the only route. You were a lawyer and then you were a judge. You were a litigator and then you were a judge. Canada has a very wide candidate pool, and many of the men and women who are picked for the judiciary come from either academics or the public, many from the public service, because they bring to the bench their various experiences. So I just want to endorse the notion that the traditional start a law firm, go to the judiciary, that ended a long time, about 20 or 30 years ago in Canada. And not only is there no lessening of the quality of the judiciary, it's enhanced by the variety of experiences that the men and women who come from those different areas bring. And at the end of the day, as Brenda says, the question is, are you actually listening with an open mind to the evidence you're hearing? Not, did you used to do family law? Did you used to do commercial law? Do you know how to listen and apply what you hear to the law? So,
do you think there's any difference in the approach of a man and a woman? Would the kind of male-dominated areas benefit from a female lawyer, or do you think there's any difference in how men and women lawyer?
I can tell you that on my court, when Louise Sharon and I were appointed together in 2004, we became 4 women on the Supreme Court. We've had 10 since 1981, when Bertha Wilson was the first woman. And people said the place felt different when there were 4 women there out of the 9 than it did otherwise. I have met some very wonderful, generous, feminist colleagues who are men, And I have had men and women colleagues who were not very sensitive to the particular needs of women. So I want the numbers increased, but I think we have to be careful in stereotyping genders supporting just that position. They do bring an experience, but I mean, any of us at our stage will tell you that it's no, just because you're a particular race, color, religion doesn't necessarily mean that's the way you're going to judge a particular case. And that's as it should be, right? I mean, you cannot say, oh, you're a woman, so you're going to be for women in every case, or against, or you're a man, so you're going to be against. That we are so much more sophisticated about how we understand judging now than we did in those days, when it was the case that you got very little sensitivity about women from many of the men who were judges. But on the other hand, some of the key rulings on behalf of women in Canada were made by men. So,
Judge Mary Flick, go ahead.
I was just going to say, I agree, first of all, with Brenda that everybody, all good lawyers or judges are lawyers first, but there are different approaches of lawyers and many different approaches of judges, some better than other. But I don't think that there is a female or a male approach either to being an advocate or to being a judge, nor should there be. But I'm all in favor of there being very significant number of women amongst the judiciary, but I think that's for slightly differing reasons, because I do think that for both the litigants, for the public in general, and for lawyers, it is very important that the judiciary is representative of both the gender divide in the community and indeed lots of other diversity issues as well. But fundamentally, every judge who is appointed must be somebody who is fit to be a judge, because particularly most judges start off in a court where they are the single judge, and they must be capable of deciding in an appropriate way, as has been said, on the evidence. And I've always had a view that how you decide a case is almost more important than what you decide, because so often for the litigants, how you decide, and certainly it has been my experience that litigants who have lost before me have come back or have sent a message, I've had it from personal litigants, to thank me for the manner in which the case was conducted, even though they have lost. And I think that's an incredibly important aspect of being a judge. But I don't think there is a difference. And I'd just like to add one thing from what Maura, I said, I absolutely agree with Maura about childcare being essential for everyone, for all young couples who are trying to work and have families in the current situation. But I think, differing to what the experiences of Brenda and Rosie have been, given that the Irish bar is still, everybody is self-employed, doesn't have the support of chambers or even groupings or whatever, there are additional hurdles for women who take time out. Because I had the experience of a judge, which was extremely unfortunate, but a young barrister was sent in, a devil, as we say, a junior who was working with somebody, sent in to apply to adjourn a case before me, because her so-called master was going out on maternity leave. And I had to say, you know, does your client know that they're asking for their case to be put off? The other side were objecting, they wanted their case on. Unfortunately, litigation doesn't wait and can't wait. I mean, there are some instances where a client may make a choice to wait and the other side may agree for reasons, but absent that, unfortunately, the litigation has to go on. And if you're a self-employed practitioner, you don't have the colleague in the firm or whatever who can do it. So there are very particular problems facing, I think, young women at the Irish bar.
Just on that, we have some questions coming in, so I'm trying to get to some of them. What else can be done to retain women and to retain them so that they can progress to be senior counsel? And is there a place for positive discrimination in terms of women and in terms of other minorities, or in terms of having a more diverse bar? What's your view on that?
Mine? Well, I think in Ireland, being appointed as a senior counsel is still fundamentally a choice for the individual barrister. So you have to apply and you have to meet certain criteria.
I think the question is, how do you retain women? How do you retain them so they get to the point where they feel they can apply for that position?
Well, come back to my point about them being self-employed. The Bar Council, since my time, has made huge strides in giving support to them. They have given them freedom from fees, various other things that support them remaining in practice through a maternity leave. Or it's not just the maternity leave, but the point of high pressure for a lot of young women is when their children are between the ages probably of about 1 and 7, and that's also the time when they might be in late 30s, early 40s, or through their 40s, and they might be coming to the point of taking silk in mid 40s and I mean, what can the Bar Council do? They can give them support, and the childcare point is extremely important, but that's a wider thing than the Bar Council. But if practitioners have more limited time available for their practice, and a lot of barristers are working, as the survey showed, 50, 60 hours a week at that stage. I mean, I'm not sure what else can be done. These again comes back to my question of choices. If people choose to be a self-employed barrister, then they do have to give it the time. And I'm not sure what other supports can be given to people.
Lady Hale, you have talked a lot, and you have been a champion of diversity and of the lack, and have pointed out the lack of diversity in the English legal system, and indeed, I think the same could be said here. A question we have here about positive discrimination, do you think that has a greater role to play, both in terms of women and in terms of ensuring more diversity?
No, I'm not in favour of positive discrimination. In other words, appointing a woman or somebody from another less well represented group, even though they are not as good as another candidate. I think that is not good for the profession, and it is not good for either of the people, either the person appointed or for the person who hasn't been appointed. So I'm not in favour of positive discrimination. I am in favour of affirmative action, that is taking steps which will make life easier for disadvantaged groups to prove their worth. Things like having a bar nursery, for example, which after a lot of effort was set up in London. Things like having an email code, which the Bar Council has promoted in England, whereby you are not expected to reply to an email if it comes in after 9 o'clock at night. That sort of thing. Practical things like that will go a long way towards helping women and other people with family responsibilities to maintain a practice. And many chambers, I mean, the chamber system is still, they're all self-employed, but it does enable a certain amount of support to be given in a way which the Irish library system perhaps doesn't. But we have to think creatively about how to make a professional life more accessible, more maintainable for women and for anybody else who's got responsibilities outside their professional life. And I think it can be done. And I can see Rosie wants to say something.
No, I don't disagree with anything I've heard. But I did want to make one observation, Orla, and that is, I'm a little troubled by a concept of positive discrimination. I don't know what that means. So if you have discrimination, it means you are arbitrarily disadvantaging someone based on their membership in a group. There's no such thing as positive arbitrary disadvantage. but I think an approach that says, we call it employment equity in Canada, not affirmative action, because that's a very inflammatory term based on what we read about what goes on in the United States. What are the barriers to the possibility of each of these groups taking their rightful place, not unmeritorious people, although, there was an old boys network which didn't have qualifications necessarily attached to it. So the question is, what is there in the system that is impeding the possibility of people who are qualified from taking positions, notwithstanding their gender? So, I mean, if you put it that way, I mean, when I hear the word positive discrimination, that's an oxymoron. How could it be good to have discrimination? So let's think in terms of what do these people tell us the barriers are, and let's examine those barriers and what can we do that doesn't implode the economics of a law firm. It may temporarily dislodge it, but lots of things do. As I said, somebody can get sick through no fault of their own and take some time off. How strict should we be about some of the concerns that women or minorities have and what is happening to them in the profession, so that over time, and quickly over time, more of them are made to feel they are properly members of the legal profession and judicial communities. So just words matter in our profession a lot. So I'm just suggesting a shift in the way that phenomenon is presented and the solutions for it.
Maura, what is your view as chair of the Bar Council? There's a question about what practical steps.
Well, I was just going to jump in there, try and stop me on this one. Well, one of the policies that we're following is equitable briefing. So basically, what that means is if 10 people are all at 100%, we'd ask the people, whether they be in the DPP's office or the Chief State Solicitor's office or whatever insurance company, whatever the large briefing network is, the grouping that has the power to send work to the barristers, that they would consider sending it to those who have passed the mark, who have proven they're capable of doing it, who are as meritorious as any other colleague, but to consider those minorities, whether they be women. It shouldn't be a fact that you don't get the brief because you're a woman. It shouldn't be the fact that you don't get the brief because you're gay. It shouldn't be a fact that you don't get the brief because you're colored. That shouldn't matter. If you have passed a particular standard and proven yourself, you should be in that mix. So it's opening up. Equitable briefing is what we're aiming for, opening up so that more people are visible to those who have the power to send the briefs out. What else can the bar do? The bar we've set up our own committee dealing with diversity here at the bar, resilience and performance, and that's chaired this year by Aoife McNichol. I was chair of that committee myself for a few years. It's aiming to open up the eyes of society to recognise that the Bar of Ireland, for example, has to mirror society. We have to ensure that children who are in Daish schools get the opportunities to come to the King's Inns and qualify as barristers. So a scholarship programme has been established in the name of the Chief Justice Susan Denham, and that allows for 4 candidates from Daish schools to get places in the King's Inns, and for the first 4 years here at the bar they're supported. So it's a case, I mean, I keep saying there's more to be done. The very fact that it took 41 years for the Bar of Ireland to elect a second female chair is just, mind-boggling in a way that it could take that
Maura, I was going to ask you, did your experience campaigning for that position give you any particular insights into some of the issues?
Well, let me see. I mean, I went about it in the way of, I had been on the Bar Council as a junior counsel. I'd had 2 years in the Bar Council as a senior counsel. And I just went about it to be re-elected to the Bar Council again. And I was very lucky that a large number of my colleagues re-elected me. And I was just very lucky that I was able to approach members on the council and say to them, look, not only is it time for a change, but I think I have the merit. I can do the job. I know what I want to do. I have a plan. I believe it has to be opened up. the diversity at the bar, not only am I from the country, not only am I a circuit practitioner, not only am I a woman, not only am I gay, I mean, what more diversity can we prove in the year 2021 that the bar is going forward? And it is going forward. And my colleagues, thankfully, have shown their support to me and for me. And it's hopefully onwards and upwards and opening up of the bar, which is for its own good and benefit.
I'm trying to take as many questions as I can. I'm just going to kind of mash a few of them together. One of them is, and maybe I'll go first to Justice Abella with this. What was the biggest obstacle you faced in your career? And aligned with that, somebody else has asked, did any men help or hinder you along the way in particular? Was there any particular standout moment where you faced a particular obstacle, and does that obstacle still exist?
I wasn't brought up to think of life in terms of obstacles. So were there things in my path that were harder to deal with than other? Of course. Were there people that helped me along the way? I could not have done what I did as a practicing lawyer, as a sole practitioner for those 4 years that I practiced law before I became a judge, without the help of my male colleagues in the legal profession. They were indispensable and they were helpful. I don't think there's also any doubt the fact that there were none of us around. Like, I was not a threat. There was one of me, and I was this adorable mother of two practicing law. Isn't that the cutest thing you've ever seen? And she's a judge. So it wasn't as tough for me as it was for other people. And I had a husband who was a history professor. He was I would say, a 60% parent. So I cannot say, having had the luck of healthy children, a great husband. My mother lived 5 minutes away and she helped us. Everything that came in my way that was a barrier was just something I had to overcome, and none of it stood in my way. Most of the people who helped me were men, because that's what the profession and judiciary consisted of at the time. Some of my greatest adversaries were also men. Some of the women in the profession were wonderful. Look, meeting Brenda was a highlight for me. Meeting other women around the world who gave each other support and said, "Go for it! Come on, we're here. We're all going to be there for each other," because there were few of us. We all helped each other deal with what we knew were going to be obstacles, because the system was as it was for 100 years. And we were coming in and saying, okay, that was then, it's a new century. Change is hard for people, because change means adjusting a status quo they're used to. And it's a status quo that isn't good for us. So we're saying change the status quo. We don't want a slice of the pie. We want access to all of it. Wait a minute, that's not your slice. You can't have all of us. That's our. We'll tell you what part you can have. Well, so this generation has fought to make sure that that pie is for everyone. We've changed the ingredients so there's more of it to go around for everybody. We've all had things we've had to deal with. It's called life. But I cannot tell you, as somebody about to retire from the Supreme Court of Canada at the age of 75, that I am a package of obstacles that I overcame. I am not. I am the product of a series of wonderful opportunities that came my way, wonderful people who helped me realize them, a great family who was there for me all the way. So I am not your model of adversity triumph.
Did you, as one female barrister or female advocate, did you encounter any hostility from the bench? Were there judges who treated you differently as a woman?
Of course, no. I was never sure if it was because I was a woman or because I was very assertive as a woman or because I was Jewish. I mean, there are no women judges on the court at the time, and I don't know that there were any Jewish. We had one, Bor-Alaskan. But no Jewish women at the time. So stereotypes kick in. But I never step back and analyze, is this anti-Semitism or sexism? Or is it just that they don't like me, which is also possible, right? I did not fit any mold. I didn't dress like anybody else. I dressed like a girl in the 60s and 70s dressed with dangling earrings and short skirts and all of those things that, and I had blue nail polish sometimes. So I never expected that I would be warmly welcomed. That wasn't their job. It was just to accept the professionalism that I was offering on its own terms. And most did. Most did.
I have a question about whether or not your background influenced how you dealt or how you saw migrant-related legal issues, or the whole issue of immigration and migrant issues. Does your own background and what you've gone through, does that affect how you deal with those kind of cases?
Oh, I think most of the judges I know, yes, of course, my experience as a woman, as a Jewish person, as an immigrant, affected me, and so did the receptivity of this country to all of the above affect me, the generosity of the country that took me in. It's very hard to say to a judge, so do you think you're more humane because you went through adversity, or do you think you're really compassionate? I like to think that I am, but it doesn't judge an outcome in a case. As Brenda says, the facts do. So I have never, unlike Mary, ever received a note from somebody who lost a case saying, "Great job." I mean, I have run into a lot of people who have said, "You got it wrong. How could you do that? That's so wrong." And in fact, when I used to lose cases as a lawyer in court, I always thought it was the judge's fault. Like he just didn't get what I was saying. Come on. I mean, it was so clear. So I never had the experience of people who lost agreeing with what I said. But I also never said to myself, "Okay, Rosie, now just be really compassionate and really humane." That's who we are, right? We bring who we are to our judging, but we also learn as judges very quickly to transcend our quotidian reality in our life and look at the life in front of you that you are judging, not from the top down, from the ground up.
Judge Finlay-Gagan, was there any particular, I suppose maybe I won't use the word obstacle, but barrier that you felt you had to overcome?
No, I think, again, like Justice Abetla, Rosie, I feel incredibly lucky. And I think, as something that Brenda said earlier, I think I came at a time, certainly in terms of appointment to the High Court, etc., where people were looking for women to become judges, and therefore I was given the opportunity. And I really can't say that, of course I met obstacles, but they were the obstacles that all my male colleagues were kind of meeting every day of the week as well. And but I never felt I met an obstacle just because I was a woman. And I don't ever recall being treated differently in court. Oh, I do recall one occasion. It was a jokey thing from the particular judge, and a bit like Brenda has said, it was a big commercial thing. There were, 10 senior counsel, and I was the only female senior counsel, and the judge in question, who knew me terribly well, and I always practiced as Mary Finlay, so I was always Miss Finlay in court. He suddenly said in the middle of everything, "Miss Finlay or Mrs. Gagan or Mrs. Finlay-Gagan, what can I do for you today?" And I remember feeling yuck. But on the other hand, I just knew it was his form and it didn't fuss me, but I never felt any serious antagonism because I was a woman. Of course, there were some judges who didn't like me and didn't like the submissions I was making, but not because I was a woman.
And what about yourself, Lady Hale? Does any incident stand out to you as a moment where you had to really dig deep, or you had to overcome a particular obstacle in your profession, in your career?
I'm afraid, like the others, I can't really say that there were specific obstacles other than the general challenges of the professional life that I've led, which is a challenging one. And I don't think it would be any more challenging for a woman than for a man. Of course, there were the challenges of there being so few of us. So obviously, those few of us who did start out in the law, why were we allowed to do it? Why did we persuade people that we could do it? So perhaps there were challenges there, but they were in terms of other people choosing to allow us to do it. So I don't think I can feel that. And I've not got many incidents. I do remember my very first meeting as a High Court judge. All the High Court judges get together in the Lord Chief Justice's court to have the headmaster's pep talk for the term. And one of the items on the agenda, there were 6 women in the room and over 100 men. And one of the items on the agenda was what the women judges should be called, because one of us objected to being called Mrs. Justice because she practiced under her maiden name. So we had this long debate about whether the women had to be called Mrs. Justice. 3 of the women were quite happy with it and 3 of us objected to it. But of course, the men discussed what we should be called, and the right thing to do would have been to drop the Mrs. and Mr. entirely. But the men were not prepared to drop the Mr. And all the pompous speeches about, oh, I was introduced to my queen as Mr. Justice X, and Mr. Justice X I will always be. So the outcome of the meeting was the men decided what the women should call themselves. In fact, we should have been given free rein to decide, basically.
I'm glad to say in Ireland.
I'm sorry. I'll wait for Mary. Mary, go ahead.
Sorry, I was just going to say that in Ireland, we were given free rein always. And I think thanks to Mela Carroll, the first High Court judge, because following the English tradition, which was that as a single person, you are Mrs. Justice, because of Miss Justice a possibility. And when Mela was appointed, she was asked, and she said she'd always practiced at the bar as Miss Carroll, and she would become Miss Justice Carroll. And from the outset, but she did initially say she would be called the same as all of her male colleagues, which always was my lord in Ireland. But now she thought better of that about 10 or 15 years later, and having chaired a commission on the status of the women, and she gave up being called my lord. But they were still calling, when I was appointed first, I was called my lord constantly, because we never called anybody my lady in Ireland because we don't have titles.
You didn't have any. Orla, can I jump in just for a second? First of all, I agree. We got rid of Mr. and Madam Justice. We are Justice. And we early on got rid of my lady, my lord, just because it felt, it was uncomfortable. I mean, it was so royal. You know, and we're people in a professional position of judging. But as the others talked, and when I tried to think of obstacles, and I can't, I have to tell you though that I can remember the biggest challenge that I had, and it was it's the public scrutiny that we get as women in our profession. Mm-hmm. So I did a Royal Commission on Equality in Employment when I was 37. Federal Royal Commission, I was a provincial court judge, on what measures should be taken for women, Indigenous people, persons with disabilities, and visible minorities. And the conclusion after a year was mandatory measures have to be taken. Voluntary won't work. It's too glacial. Not quotas, but over time, measure the rate of change. It landed into controversy from one end of Canada to another. There wasn't a single newspaper that endorsed it. Now, having come from adorable mother of 2 appointed to the bench to the virago of the Western world, from every newspaper in Canada, it was a challenge to me. It wasn't an obstacle, but it was a challenge, not because it was a professional potential barrier, but because I didn't know how to deal with the vituperative criticism. It wasn't, well, we wouldn't do it that way. It was, what is she thinking? Ridiculous. Now, over time, I taught myself that if I like where the criticism is coming from and can understand it, because there is criticism when you take controversial positions, and that's why judges have tenure, because we're supposed to be ready to risk public criticism and controversy, because we're not going back for elections every 4 years, the way the politicians are. So I made myself a mental template. If I like who the criticism is coming from or understand it, and I like where the support is coming from, then I say to myself, well, that's fine. I can live with that because it means I've earned my friends and I've earned my critics. So I had to make peace with public disapprobation, which wasn't anything I was used to.
It would be a lot worse now, I imagine. And I think the Chief Justice, or the incoming Chief Justice here, referred to it, the social media aspect of it now.
Absolutely.
Immediate.
There's no question. And that was in the days before there was now, but I learned to be comfortable with criticism, with public criticism and public controversy. And the older I got, what was controversial, human rights in employment, is now second nature. Everybody's saying, how do we get diversity going? So you have to have in your head a little angel that says, it's okay. Let's see how time judges this. The agitations of the moment will not tell you whether you did the right thing or not, but time will. And so over time, all of my controversies have turned out to be really boring of courses. And that makes me feel good. So you have to take those risks professionally, but they are not obstacles, Orla. They are the challenges of doing what you think is the right thing to do as a professional, male, female, or whatever.
I'm just conscious of the time now, so we won't get to all the questions, but one question that might be of value to all the speakers as a final question is a standout career moment. And aligned with that is, is there anything you'd have done differently? So maybe Lady Hale, would you have a view on that? Is your standout career moment the one we all remember, the most recent one? Or is there something in your career that you're particularly proud of that did not attract such public notice?
That's a very difficult question, isn't it? Because the prorogation case was definitely a standout moment. It was the most important constitutional case that's come before the Supreme Court of the United Kingdom, or indeed the House of Lords before that, for a long, long time. And there were many challenges involved in actually putting it on, deciding it. We decided it quicker than almost any other Supreme Court case, and we were unanimous. So that really was a standout moment. I am very satisfied with some of the law reforms that came from my time at the Law Commission. And if I could just respond to something that Rosie's just said, I was vilified as a legal commissar subverting family values for some of my family law reforms. But what was rejected in the 1990s has just got on to the statute book in 2020. So I always say about law reform, never say never, its time will come.
There's a theme of I was right all along, and you'll find out and coming here. Is there anything you'd have done differently?
Oh, probably all sorts of things, but it's difficult to think of examples of things. If ever I have upset people without meaning to, I mean, sometimes you mean to upset people, I mean, colleagues or superiors and so on. You mean to challenge them, even if they're going to be upset. But sometimes you can upset people without meaning to. Have I time to give an example?
Yes.
And it is an example of something which we didn't mention when we talked about different styles of judging amongst men and women. The one difference that we do have is that as women, we lead different lives from men's lives. And sometimes our experience of leading a woman's life informs our view of a case, which otherwise it wouldn't. We had a case about an elderly woman who was not incontinent, but because she had had strokes, she needed help to go to the loo in the middle of the night. The local authority had been providing her with that help, and they suddenly decided that instead they would provide her with incontinence pads. She was outraged. She thought this was an affront to her dignity, and she challenged it. And my colleagues thought it was all right. I took the view that it was irrational to meet one need with something that was designed for a completely different need. That was my view. But that was partly I think, informed by my knowledge of a woman, of how difficult it is to go to the loo in the middle of the night. Whereas the men, of course, as somebody pointed out to me later, and forgive me if this is indelicate, but we women are prepared to talk about bodily functions, men can always pee in a bottle. So as far as they were concerned, this was no big deal. But when in my judgment, I pointed out that logically, if the local authority could do this, if she needed to urinate in the night, they could do it also if she needed to defecate in the night, and indeed they could do it during the day. My male colleagues were outraged. They were really upset by my reference to defecation, logical and inevitable though it was. And I am sorry that I upset them. I didn't mean to upset them. I nevertheless thought it was important to make the point. So yes, that is probably the greatest regret of my professional career. So there we are.
Well, thank you for that. And what about yourself, Judge Finlay-Gagan? Have you something that stands out in your memory very, very starkly, or is there something you would have done very differently?
I don't think I have or care to refer to either a standout case in which I pleaded as an advocate, or there were certain cases that came the right way that I was both pleasantly surprised and very satisfied with. And of course, there were others I lost. And like Rosie said earlier, at the time, I certainly just believed I just got it wrong. But I think as a judge, for me, of all the different opportunities that I was given, the opportunity to have been part of the group of judges who established the new Constitutional Court of Appeal, that was really a fantastic opportunity. And it was given that what the then Supreme Court in their wisdom thought was wise to send us so many cases to deal with, and the manner in which we collectively managed to approach the very enormous task we were given. That was, to me, the standout moment in my judicial career. In terms of things that I regret or think I did wrong, I've no doubt that in particular where I gave extempore judgments, perhaps at the end of a day doing a long list of short applications, and you just wanted to finish and do it, I'd say that once or twice I foolishly decided I would there and then give a ruling which I began to reflect on. And it's something that I've always said to younger judges starting off, you know, if you have the opportunity, if you're going to give even an extempore ruling, perhaps just keep it overnight and just reflect on it. And, you know, I'd say I did reach incorrect decisions. Of course, I reached lots, as a High Court judge, I reached lots of decisions, even in the Court of Appeal, that my superior judges thought were wrong. But that's a different thing to doing something which you yourself the next day or day after think, if I'd only taken my time a little bit more and reflected a bit more. And for that, I am obviously sorry.
What about yourself, Judge Abella? Have you any standout moment for yourself, or anything that really sticks out in your memory, or something that you would have done differently?
Well, first of all, no, I have no regrets. And again, I don't ever look back because there's no point. I don't do a shoulda, coulda in my life. I'm sure there are things that could have been different, but I really don't think about it. My only regret is that I didn't have more time, that there weren't 36 hours in a day instead of 24. But judicially, I think the hardest judging I ever did, without naming a case, was 7 years as a family court judge, deciding day in and day out whether to take other people's babies away when I had 2 of my own. Because there was nobody who could help you and nobody who could tell you whether it was going to turn out to be in the best interest of the child. On the Court of Appeal, I got to decide the first gay rights decisions. I have had a chance to make constitutional judgments about whether or not women should be pay equity cases, that the Charter of Rights and Freedoms includes the right to freedom of association, includes the right to strike, that the customary international law is part of domestic law. I mean, there have been wonderful, wonderful opportunities to do law. Copyright. I've loved my copyright cases too. But I have to tell you, and I say this, and I forgive me if it sounds maudlin, but I take nothing for granted, and I take no one for granted. And again, I'm sure that's because of where I come from. To be able to say at the age of 75, on the verge of retirement, that I have nice sons, that the kids are good, because I knew no mothers who were lawyers when we got pregnant with our first, and certainly I know there are many now, but this was an experiment I had no idea was going to succeed. And by succeed, I meant, are they nice people? Now I can tell you that's what I take the greatest pride in, the fact that these two men now, 47 and 44, are nice people, and they're both lawyers. So
maybe you did do something wrong.
as I say to my husband, who's a history professor, with the greatest dignity, they became lawyers. So this is something I have waited for. I've never given interviews until now, those how do you manage interview ever, because I didn't know if I would. So those are the life blessings that you look back on and say, professionally, of course, it was a privilege, but what really lasts and what matters is family to me. And they are all three of the husband and two boys and their families. They're nice people. They're wise, and they're caring, and they're generous. So that's my biggest satisfaction in life.
And they're lawyers, which is a double achievement to make them nice, caring lawyers. I'm conscious of the time, and I honestly, sometimes when you start these kind of discussions, you wonder, are we going to be able to keep talking? And honestly, I think we could go on for another hour. It's absolutely fascinating. All of you have such wisdom to impart and such great insights for women and men and for all of us. And I think Judge Abella is definitely going to be a motivational speaker in her next career, but no regrets. Don't look back, and you'll be right in the end, and you'll be proved right in the end. It's been wonderful for me to listen to you all. I hope for there's still more questions coming in, and people are delighted with the insights you've given here today. I want to thank you all so much for speaking to us, and I'd just like to hand back to Maura, who's going to close tonight's discussion.
Well, thank you, Orla, for agreeing to act as moderator and to ask all the questions. And before we finish, I would just like to thank, not just personally, but on behalf of the bar, I would like to thank Baroness Hale, Justice Abella, and our own Justice Mary Finlay Gagan. And in addition to thanking our sponsors and to thanking everyone who's tuned in, I want to thank our Public Affairs Committee, which is run by our own Paul Gunning. So thank you for all your support. And then finally, I would like to express our congratulations to the first female Chief Justice. Lady, I don't know now, I'm confused. Should it be called Lady or Miss? The new Lady Chief Justice in Northern Ireland, Justice Egan. So we would like to extend our thanks to everyone and congratulations to her. And please God, we'll see everyone in person next time round.
Let's hope so. Thank you. This has been fantastic. I love doing this with Mary and Brenda and Orla and Maura. Thank you so much. What a joy it's been.
Thank you, everyone. Thank you so much.
And for us too.
Thank you so much. Thank you for your time.